Good afternoon, everyone. Thank you for coming. We're going to begin relatively on time, so we stay on time. So thanks very much for being here. My name is Ed Martin with the Eagle Forum Education and Legal Defense Fund. We're grateful to be gathered again, our fifth annual event. We really believe so strongly in the importance of this issue, the issues surrounding patents and our patent system, and we also believe so strongly in the community that's developed to work together to protect patents and protect our great system. So thank you again for being here. I did want to recognize, before I introduce our own Jim Edwards, recognize John Schlafly, who appears to have left the room, which is typical John. John Schlafly is one of our senior folks at the organization. You may recognize the last name. He's Phyllis Schlafly's oldest son. I hope you'll have a chance to meet him. He's very good on this issue and a really great part of our team. And also recognize Woody Woodrum down front here. Woody will be with us tonight. Woody is our California leader our California Eagle leader, and came all the way across the country with his wife Donna to be here, and we thank them for their great work there. So I will get out of the way except to say thank you again to our panelists for being a part of this, for all of you being a part of it, especially for the great supporters of this event. We believe so strongly in what we're doing and building this community. If we can be of service to you, I know many of you pretty well, but those of you that don't know as well, if we can be assistance in any way, our organization stands ready to do that, whether it's our meeting space, our great Eagle leaders across the country, or whatever it may be. So having set all that up, I welcome you. We are recording the event. We do that so that we have the ability to post it so people can view it that couldn't be here, and so we look forward to that. I will introduce next our own Jim Edwards. Jim Edwards is no stranger to you all. He's worked up on the Hill in many capacities, and he's our lead worker on this issue. He both teaches us how it works and also helps us to get influence, and this is his dream and his work to have these great events, and so we salute him in anything he tells us to do within reason. John and I do, and our organization does. So let me turn it over to Jim Edwards so we can have a great program. Thank you, Jim.
Thanks, Ed. Welcome, everybody. Let me mention a couple of things. One, we want to thank all of the sponsors of our event and really appreciate the support to make this happen. We want to thank Bio, the Acacia Research Group, Dinsmore and Shohl, the Innovation Alliance, and InterDigital. So I don't think I left anyone out. We appreciate the support. I also want to importantly mention one thing. Coffee and tea are next door in case you get thirsty or need some refreshment. Let's see. You know, in 1980, the Supreme Court handed down a landmark ruling, and it found that a man-made living microorganism was patent-eligible subject matter. The court invoked the phrase connected with Congress's 1952 rewrite of the patent statute, and that is the Section 101 of the Patent Code law generally regards anything under the sun that is made by man as being patent eligible. Well, that was then, this is now, and things have changed a bit, and that's the subject of this afternoon's program. So we appreciate your being here and your interest in examining what has happened in 101, going from anything under the sun made by man to pretty much depends which judge you get and which court you get and which day of the week it is. So we have three panels who will be discussing the elements of this, and the first panel is going to look at the kind of the background, we call it validity goulash, which is a great term crafted by now Chief Judge of the Federal Circuit, Kimberly Moore. That's what the essence of 101 doctrine is today is validity, patent validity, goulash. So we're going to look at how things have changed from what was the Diamond v. Chakrabarty opinion about the patentability in 1980 to, if that's the book of Genesis is Chakrabarty, then we're going to, in our panels, are going to go all the way from in the beginning to Job, where there's pain and suffering and hardship, to all the way to Book of Revelation with the 4 horsemen of the apocalypse. So buckle up. And I'm not too off in exaggeration land on that, I don't think. Laurie Self is going to manage the first panel to get us going. And Laurie is Senior Vice President and Counsel of Qualcomm, and she's with Government Affairs at Qualcomm. Qualcomm is one of the country's leading R&D companies in telecom and wireless technology. Laurie Self represents the company before Congress and the U.S. government offices and within professional and advocacy organizations. She supports Qualcomm's strategy and initiatives promoting strong IP rights, including in emerging markets. Her particular focus is to ensure that U.S. intellectual property and trade policies have the necessary protections and incentives that support Qualcomm's R&D-based business model. Now that's important, but it's also important for everybody else who has an R&D business model. So, but she doesn't advocate for them. She only advocates for Qualcomm. Before joining Qualcomm, Laurie was a partner at Covington and Burling, and there she headed the IP section. And I should mention she also testified in 2019 at the Senate's marathon hearings with 45 witnesses. Well, she was one of the 45. And she's generously and graciously been a speaker for us on many occasions. She's back, and I'm sure glad for that. Andrew Baluch is a partner and intellectual property attorney at the law firm of Smith Baluch. He formerly was a partner at a large international law firm and even headed the Shanghai office in China for a year. He's an expert in IP litigation and patent portfolio management, not only domestically but globally. Mr. Baluch served in 2011 in the White House Office of IP Enforcement Coordinator, i.e. the IP czar's office. He also was legal advisor to Director David Kappos at the USPTO and Andy clerked at the Federal Circuit. Andy Baluch, his writings have been cited in opinions of the Federal Circuit and other federal courts, as well as congressional committee reports. And he's the author of a book, the 27th edition of Patent Reform, and he too is a returning speaker. I first met Manus Cooney when he was a counsel on the Senate Judiciary Committee. Later on, Manus went to the top of the class as the chief counsel and staff director of Judiciary Committee Chairman Orrin Hatch. There, Manus played a pivotal role as the committee's chief advisor to the chairman and its members. After the Hill, Manus became senior vice president at Napster, the file sharing company, and he then headed 2 consulting firms over several years. Today he's with American Continental Group as a partner. It's a consulting firm that you're probably all well aware of that deals with many clients in the patent and IP space. Manus focuses on IP, competition, and administration of justice issues. So welcome to all of you. Laurie, it's all yours.
Okay, do I need to turn this on, Jim, or?
It's on?
Okay, perfect. So thank you for being here. It's rare to do a live event, at least for me, so it's exciting to see actual people, not on video conference. So as Jim said, we are going to serve as a kind of historical scene setter, with Andy focusing on the kind of historical evolution of case law, Manus talking a bit more about what's happening on the legislative front, to kind of right the wrongs, if you will, of the Supreme Court in recent years. On a personal note, Jim mentioned Diamond v. Chakrabarty as the the sort of Supreme Court jurisprudence that sort of stood for a very broad, flexible interpretation of Section 101. In that case, gave birth to a large extent to the biotech industry. A few years ago, one of Qualcomm's leading patent coalitions, Innovation Alliance, worked with Dave Kappos to put together a panel on Section 101 when we saw this really disturbing trend line. And one of the guest speakers was Dr. Chakrabarty, who was the lead inventor patent owner in that case. And I will say, in hearing him talk about how his life's work was on the cusp of being destroyed, if you will, by these 101 cases, it was candidly devastating. So there are real world effects that are very dramatic in terms of how 101 has evolved and served as a kind of gating function for access to the patent system. And so I just wanted to kind of provide that anecdote, if you will, just to sort of emphasize how quickly the tables can turn through Supreme Court jurisprudence on the patent system, and in ways that help enable massive invention and economic growth, in ways that very quickly shut the door on different types of innovation and growth. So with that opening, I'm going to turn to Andy. And in your career, tell us how you've sort of witnessed this evolution or devolution, if you will, in Section 101, and your thoughts on some of the impacts from that.
Yeah, definitely.
Yeah. Yes, of course.
So, as if on cue, I thought about how much things have changed since I started practicing patent law. And so I pulled up the 2004 version of the Manual of Patent Examining Procedure, which I studied from to take the patent bar, and then comparing it to where we are today. So the 2004 version of the MPEP, as it's called, has a tiny section on patent eligibility, living subject matter, and computer-related inventions. And then it goes on and on. The balance of it is all about the other requirements of patentability: novelty, obviousness, written description, definiteness, enablement. So it's a tiny section, and it actually starts with, it instructs the examiners to determine whether the claimed invention complies with 35 U.S.C. 101. Consider the breadth of 35 U.S.C. 101 under controlling law. As the Supreme Court has held, Congress chose the expansive language of 35 U.S.C. 101 so as to include, quote, anything under the sun that is made by man, which is what Jim quoted from. That's actually from the bicameral Judiciary, House and Senate Judiciary Committee reports from 1952 during the rewrite of the 1952 Act. And it's really a straightforward, easy to apply back then, just in 2004, because in 2010 comes Bilski. Fast forward to today, the 2020 version of the MPEP that the examiners have to apply. Now, just the table of contents has 2 columns full of that 101 analysis, thanks to Bilski, Mayo, Myriad, Alice. And it breaks down in this complicated way, unfortunately, that the examiners have to apply. There's a step 1, a step 2A, a step 2B, a prong 1, a prong 2. And it's got flow charts that examiners have to walk through. And these, examiners, there's 8,000 of them. They're not attorneys. They haven't. The vast majority of them have not gone to law school. They are technologists, scientists, engineers. So, obviously even courts today, the judges of the district courts and the federal circuit are having trouble applying these, and we expect our 8,000 non-attorney examiners to apply it. The other striking thing is that in the now 97-page long section on 101 eligibility, the term anything under the sun made by man is eligible is nowhere to be found. It's been scrubbed away, unfortunately, because of the changes in the case law at the Supreme Court. They've basically undone all of that. So just as a tangible difference, you can see how much has changed in this time.
Thank you, Andy. So Manus, there's been a tremendous amount of legislative activity over the past couple of years at least to try to bring some clarity, if you will, to this goulash, as to paraphrase Andy's comments. And again, just to state what you all know, when we talk about goulash, or Jim talks about goulash, what we're referring to in part, beyond just the sheer complexity of current 101 jurisprudence, is this conflation, if you will, between eligibility standards and what are traditionally viewed as sort of the statutory patentability requirements. So conflation between 101 and, on the other hand, 102, 103, 112. So Manus, there has been an effort among a number of stakeholder groups to bring some legislative guidance and clarity to the judicial goulash. Can you help us understand what that dynamic currently looks like and why we haven't seen a legislative solution to date?
Thank you very much, Laurie. First of all, let me just thank and remind everyone how fortunate we are to have Jim Edwards working on these issues. He's seen by everyone in Washington as a man of character, and just somebody whose integrity cannot be questioned. And so when he comes in and pushes an issue and asks for members of Congress to consider his position, they listen. And so we're very fortunate to have him fighting for property rights and working on this issue. Eagle Forum is very lucky. So thank you, Jim, for including me here today. And I think that, Laurie knows, and we take it for granted, many of us here in Washington, that patent law is very complex, and you add on that the 101 complexity, and as we just saw from some of the from Andy's diagrams there, getting members of Congress to understand that complexity and try to drill down on it is daunting. Congress has little to no patience to learn anything new. They have limited subject matter knowledge on these issues. It's no secret to anyone here that the Congress is sharply divided along partisan lines. And so there's a preference, frankly, for members when it comes to intellectual property matters to seek consensus. The challenge we've been facing, and I commend Dave Kappos, who's here today, and others who've been driving and trying to get the Congress to drill down on these matters and try to come up with a solution. The challenge has been that at the outset, much of the discussion and effort has been to try to come up with and formulate a consensus product that includes stakeholders to the discussions who really prefer the status quo. And when you're in that dynamic, and somebody knows they don't really need to ever agree to anything, and they prefer not to have anything pass, it's difficult. And as a result, I think that the advocates for 101 are doing our best to try to get the Congress to take this on seriously, but it doesn't take, it's an uphill effort. While we're working on this, we see the Congress at the same time introducing legislation that weakens PTAB, that weakens ITC protections for intellectual property owners, that changes the enforceability of patents generally. And we have an administration, I think it's fair to say, that is simply just not as committed to the importance of the intellectual property rights as the previous administration was. We have a executive order that was issued by the President of the United States that directs the federal agencies to formulate rules and regulations to promote competition and fairness in the marketplace. And it mentions patents at least 9 times, I believe, as examples of where fairness is lacking in the marketplace and where regulators need to step up and start promulgating rules and regulations to diminish the enforceability of patent rights, and to make things more fair and open. And the challenge there is that, as we all know, we took civics. Congress writes the laws and the executive branch is supposed to enforce them. But sadly, right now, I think there's a dynamic where I think there are folks who would prefer to see, who have little to no trouble promulgating regulations that are hostile to intellectual property, and forcing those who are who believe in strong intellectual property rights to go to court to challenge them on those regulations and those policies. And it doesn't certainly create an environment where Democrats in the Congress are going to be eager to take on the administration and do anything that's inconsistent with their views on intellectual property and patents in particular. With respect to the 101 process, 101, there has been an effort, as Jim alluded to earlier, there were hearings held 2 years ago where a bipartisan outline, a proposal of legislation was developed. Soon after the hearings, the House withdrew from those discussions that we were working on, and since then it's largely been a Senate exercise. And again, the Senate exercise, the Senate recently, and the Republicans in the Senate, Senator Tillis, has launched a series of meetings with, I think, 15 to 20 representatives, stakeholders on the pro-101 reform side want to see clarity and improvements to 101, and those who would be in the skeptics crowd, and have had some conversations. I believe they've had 2 meetings in recent months, and some progress was actually made in the last meeting. I'm an observer, but I'm not a participant directly in those meetings. And it helps to inform the discussions, so you have a better perspective, sense of why big tech has concerns with particular changes. But in the end, I don't know that it's going to this process will lead to a bill that moves, that becomes law, because as I started out saying, in order to really get anywhere on this issue, I believe big tech is going to have to be dragged kicking and screaming to get there, because they prefer the ambiguity and the like, and it's easier for them to challenge patents.
So Jim should cut me off when I'm out of time, but so one of the issues I just want to talk about from the legislative perspective is, as Manus said, Andy, we're now embarking upon a pretty active patent legislative season with the recent Leahy-Cornyn bill. How should we prioritize the 101 issues from a legislative perspective versus these other issues? I mean, one of the dynamics I think that's really important to keep in mind as we think about 101 and its role as a kind of gating function is we're talking about potential effects on technology sectors, whether it's AI or 5G or biotech or what have you, that really are critical from a national security perspective, from an economic security perspective. So recognizing all of the complications and complexities that Manus described, how would you advise Congress to prioritize this issue?
I think the 101 issue is the gating factor. It's the most important of the issues to tackle by the Congress. It's a matter of national competitiveness. China, if you look at their patent examination procedures, and I've compared and I've shown you the USPTO ones that have flow charts of 101 analysis that examiners have to do. We're the only country that requires our examiners to go through all of that, diverting all of that effort and analysis to that, and cutting off the areas of innovation in the U.S. that are eligible for patenting. Whereas in China, they have very clear guidelines that call out examples of artificial intelligence algorithm or a big data algorithm such as deep learning, classification cluster, or the like. This is a translation of the Chinese patent examination guidelines and instructing the examiners to allow patents in this field. Other example, big data in specific application fields and classification clustering, regression analysis, neural networks, etc., to mine the intrinsic correlations in the data in conformity with the laws of nature to accordingly solve a technical problem. This shall be deemed patentable under paragraph 2 of the Chinese patent law. Compare that to what's happening in the courts in the United States when a garage door opener in the Chamberlain case in 2019 is deemed abstract. So the Chamberlain's patented invention was on a movable barrier like a garage door with a wireless data transmitter for sending information about the status of the door. I don't know about you, but I think of a garage door and the electronic hardware to be pretty tangible, concrete, and not a philosophical abstract idea. The court at the Federal Circuit applied the Supreme Court's so-called Alice Mayo two-part framework, which asked first whether the claims are directed to a patent ineligible concept, such as an abstract idea, and second, whether the claims contain an inventive concept sufficient to transform the abstract idea into a patent-eligible application. At step 1, the Federal Circuit looked at Chamberlain's claims and focused on the claimed advance over the prior art and determined that the only difference in the prior art and the claim was the wireless communication, and determined that that was an abstract idea. And then at step 2, the Federal Circuit determined that there was no inventive concept because each of the individual components was known in the prior art. So this is where we are now in the US, where a garage door opener is too abstract, whereas China is instructing its examiners to allow patents on artificial intelligence algorithms, deep learning, and neural networks.
So I'll just keep going on until somebody tells me to stop. Manus, you mentioned the executive order on competition. One of the major objectives of that executive order is to deal with the so-called digital platforms and their kind of dominant position as gatekeepers. At the same time, that order does call for measures that would weaken patent rights. As you and I well know, and Andy well knows, the sort of leading advocates, if you will, for weak patent rights have been the digital platform companies, the big tech guys. How do we, so there's this kind of disconnect, if you will, in terms of these policy initiatives, and this is not just limited to the Biden administration. We've seen this historically, right? So as a legislative strategist, what do we need to do to kind of broaden the lens, if you will, in terms of how these patent issues are viewed? Do we need to get other parts of Congress, for example, involved, beyond just the Judiciary Committee, which of course has jurisdiction, but would welcome any thoughts you have about how to break this impasse?
It's a great question, Laurie, and if I had, a crystal ball and could predict how this will play out and had the solution, I would have already, monetized it by now. I'm a lobbyist. That being said, I find it quite ironic that if you do a Google search for Congress, intellectual property, and theft, most of the rhetorical statements and statements from members of Congress will be about China stealing our intellectual property. But and we need to be tough on China. But at the same time, many of these same members are introducing bills to make it easier for China and others to weaken and steal our intellectual property. It's as if there's a absolute disconnect with respect to their own policy, their understanding of the policy issues at play here. And I think that what happened was years ago we had a very strong narrative that was developed by technology that was about patent trolls, and that they framed this as a litigation issue, and that this was an issue that was costing small business and innovators money, and have succeeded over time in turning, in making that argument and using those arguments to weaken patent law. Today, that's kind of carried over into administration policy and academia, where, look, the person who's the antitrust czar, the competition czar in the White House is an academic. His views are pretty well known. He writes and publishes articles, and what he intends to do, we know. He's going to try to use his authority as, and that use the government's authority to issue regulations to diminish the enforceability of intellectual property, period. He views it as a monopoly that's inconsistent with what's fair and good for, in his mind, consumers or the public, and he's going to do it via various agencies. I think what we need to do, but that's different, is to begin to work with other committees of jurisdiction, for example, the intelligence committees and the like, to start educating them on what's happening with our intellectual property infrastructure, and take it and move from there. The Ag Committee on what is it they intend to do with respect to ag patents, seed patents, and the like, to make. Are they going to condition your ability to get an EPA approval for a product on your willingness to give away your patents? I mean, who knows? I mean, that's some of the stuff I'm trying to think through and anticipate. A final point, I think that Congress just takes for granted, and public, I think, takes for granted that all of the innovation that occurred here over the last 20 or 30 years, thanks to the internet and 3G, will continue, here in the United States. The reality is that we are the platform in the country into which a lot of this technology was deployed and and developed and marketed and sold overseas. So if you wanted to develop and attract investment into the next great internet application, or you had a wireless product you thought, or a business that you thought was a sure home run, or a biotech pharma solution, you would come to a new drug, you would come to the United States. What happens in 10, 20 years when, that dynamic, that environment is more receptive in China than it is here or in other parts of the world? Do we think that those jobs, those opportunities, that investment is going to remain? No. And that's something I think we need to do a better job, frankly, of forecasting and telling and educating members of Congress on. They just don't appreciate the long-term consequences of what may happen here.
Thank you, Manus. Andy, I'm going to give you the final. Do we just a couple of minutes? Okay, I'm going to give Andy the final word for closing comments.
Yeah, Laurie, you also asked, how do you balance out the competing priorities? So there's the PTAB IPR bill that Senator Leahy has introduced, and that in the prior Congresses, the Stronger Patents Act by Senator Coon's address, versus the 101 issue. Well, the 101 morass actually exacerbates the PTAB IPR problem. And the reason is because examiner hours is a finite resources. Every minute and every hour that an examiner is spending working through a 101 problem through the flow charts is an hour or a minute that they're not dedicating to the 102 prior art search, a 103 analysis, explaining why the prior art is not obvious to combine, providing rationales, ensuring that there's claim clarity and sufficiency of disclosure, and which again is unique. The 101 analysis that the USPTO examiners do is far above what any other office's examiners have to do, and it makes the PTAB IPR problem worse because they have less time to find that prior art, to explain why they're finding the claims non-obvious and new over the prior art. And as someone who, I've been on IPRs on petitioner side and the patent owner side, so I've defended patents, I've challenged them, and as the challenger, you really just need to go do a prior art search, commission a couple firms to do it. They come back, you find the list of references that they think is closest, you compare it to what the examiner did or did not find, and whether there's a sufficient explanation in the prosecution history by the examiner, and then you draft an IPR petition to target those weaknesses. It would be much harder to launch a strong IPR petition against a patent that has been really thoroughly examined and where it's very clear what the examiner has considered and the reasons for non-obviousness, for example.
Thank you so much. Thank you, Manus. Thank you, Andy. Jim, we'll turn it back to you.
Thank you, Laurie, and thank you, Andy and Manus, and thanks for the kind words. But thanks, not so much thanks for the bad news of where we've gone from Bilski to Mayo and Alice and its litany. I think my favorite example of the absurdity of the state of 101 is what Hans Sauer said in his testimony at the Senate. He said that he found it at least remarkable that the court deemed the invention that American Axle had as not patentable because it was vague, and he said, it was abstract, when in fact it was something that you could physically drop on your foot. So that's where we are. Thank you for Laurie and the panel for telling us kind of the lay of the land of the goulash. And we're going to have the second panel, if y'all would come up, please, and discuss the unsettled patent eligibility standards real-world effects. So, Brian, Kim, David, please. For this, we've got a couple of other attorneys and a newbie on our team as speaker. First, let me introduce Kimberly Chotkowski. She's Vice President and Head of Licensing Strategy and Operations with InterDigital. And InterDigital is an innovator that designs and develops advanced technologies that enable and enhance mobile communications and capabilities. Ms. Chotkowski worked as an electrical engineer before entering law practice. She spent her first 5 years, or round one at InterDigital, as IP counsel and working on intellectual property strategy and litigation. She served as CEO of the Licensing Executive Society USA and Canada. Kim returned to InterDigital after that to lead the licensing part of InterDigital's operations. In 2019, Kim was one of those witnesses at the Senate IP subcommittee on patent eligibility. And again, she is a returning speaker for us, so welcome back. David Lachmann is Senior Director of Federal Government Affairs for the Biotechnology Innovation Organization. And he is focused on intellectual property, trade, and antitrust matters at BIO. BIO is the world's largest trade association of biotechnology companies and related organizations in the U.S. and other countries. BIO's members operate at the intersection of biology and technology, and they're involved in curing patients, protecting the climate, and nourishing humanity. Before joining BIO, Mr. Lachmann served in staff positions on Capitol Hill in the U.S. House. From 1997 to 2014, he was on the House Judiciary Committee staff. Well, that's where our paths first met. He concluded his service as Chief of Staff of the Subcommittee on the Constitution. Welcome, David. Brian O'Shaughnessy is past president and board chair of the Licensing Executive Society, everybody join me, USA and Canada. And he's a partner in the law firm at Dinsmore and Shohl. He chairs Dinsmore's Transaction and Licensing Group. Mr. O'Shaughnessy is an internationally recognized authority in technology licensing agreements and commercial transactions involving IP rights. At Dinsmore, Brian counsels clients in strategic development and utilization of IP portfolios, and he represents them in forums such as before PTO, federal courts, and the ITC. International Trade Commission. He served on the LES Board of Directors from 2007 till 2019 as president and past president, and is currently LES's Senior VP for Public Policy. Besides that, he's got a family and some things he fills his time with besides just patent work. And he is a repeat speaker, and welcome back, Brian. So I'm actually going to lead this panel, and I'm going to pose some questions to our panelists and direct them to them, and we will work our way through. What once was understood to be a broad threshold question, Section 101, that test has gone from predictable, as Andy well illustrated, to quite unpredictable. And the damage from this judicially created mess, yes, we'll blame it more on the judiciary at this point because of the snowballing effect of the judicial outcomes. So that what this panel will examine are the consequences of turning 101 into a minefield of uncertainty. Specifically, we'll discuss the harms of harms to innovation, weakened patent rights, and disruption of rule of law, and the limits of the 101 guidance. One aspect of damage to 101 morass causes harm to innovation. So focusing on innovation, this is especially serious because the essence of invention and patents is innovation. So what are some ways in which innovation is set back by the uncertainty of patent eligibility? Kim, I'll ask you to answer first.
Sure. Well, uncertainty is never good. So in business, you never want uncertainty because you never know where you're going to be heading with your next product, your next financial opportunity, or your return on your investment. So what it has done for us as well is made sure that what we're looking at is to steer clear of the areas that have uncertainty. So where we may have taken an opportunity to invent or develop or have innovation in certain areas that potentially would be covered under an ALICE or a software or some kind of a 101 finding, we've diverted those types of funds and made sure that that innovation is really in an area that we have certainty in. We're global. We have to make sure that whatever investment has a positive return. Our research and development is worldwide, and our capabilities are strong. And if you look at where some of the engineers would really like to focus some of their time, we might have to modify that based upon where we need to be. So it's definitely impacted that aspect of our business.
Thank you. David, how would you assess validity goulash as stymieing innovation?
I'm really not happy using the word goulash in this context. I love
As a
goulash,
derogatory
especially
term.
My mother's, although plainly it's much better on the plate than it is in the patent office. But it is a serious question, and certainly for the biotech field, it's hugely important. 70% of all innovation in the life sciences occurs in small to medium-sized companies. A lot of these are startups. A lot of them are pre-revenue. That is, they do not, in fact, have an FDA-approved product. It's highly risky research. Once you get to clinical trials, which is fairly far along, you have a 90% failure rate. And my wife is always impressed when she finds out I work for companies that don't have revenue. She thinks that says everything you need to know. But people invest in this research, and they do it because when it does work, you have something extraordinary. And if we learned one thing in the last year, it's something extraordinary that can save millions of lives and get our economy back working. So there are real consequences when you take entire areas of scientific endeavor, of innovation, which is our middle name, and simply wipe them out. Nobody will invest in the development of an idea if you do not have clear, enforceable rights to that idea. That's just not how it works. And the U.S. leads the world because, in this field, because we have a strong patent system and, can I say free markets in this room? We have free markets, and people will invest in high-risk, high-cost, long-term research because of that. And so the consequences of that uncertainty, of not knowing whether you will in fact have a patent-eligible invention at the end of many years of work, are monumental. And we've seen specifically certain areas of research, if you're using, say, enzymes or naturally occurring bacteria, or there was a genetically engineered sheep that was not patent eligible because it was deemed natural, which comes as a surprise to all of us. But it's a real problem, and so certainly in this area, and our competitors, and as Anna Mossoff and David Kappos and other authors have pointed out, these are areas where our competitors in China and in Europe do grant patents, and it's quite clear. And it is not written in stone that we're going to lead the world in this sector. We didn't always. In the 80s, it was Europe, and we came up with a great formula, a great stew of law.
Not to be confused with goulash.
Not at all, which allowed us to seize the lead. And the Chinese communists are being very good capitalists. They understand what it takes to grab the lead, and they're doing it. And if we give it away to them, shame on us if we're buying the next generation of oncology drugs from Beijing instead of from the Bay Area or from New Jersey.
Well, another outcome of result-oriented judicial activism, and that's a phrase from one of my new favorite judges, Kimberly Moore, is the 101 diminishes IP rights. It renders patents unreliable in terms of the patent itself and the rights thereto. So, Brian, how has the 101 mess diminished IP rights and patent reliability?
Well, I think, what I'm focusing on right now is Laurie's comment early on where she said Diamond v. Chakrabarty resulted in the birth of the U.S. biotech industry. And she's exactly right. I mean, up until then, we were not the leaders necessarily in that industry. Diamond v. Chakrabarty changed that and made it a reliable asset that people could invest in, commercialize, and monetize. And so there was a dramatic shift from that point. Thank you, David. There was a dramatic shift at that point. I recall at the time that many commentators in Europe thought that America had gone completely off the rails, that we were going to, go down the path of patenting new life forms and recombinant human beings and God knows what. We rather deftly avoided that charge, and I think under the leadership of people like Dave Kappos, we very effectively organized and followed a policy that nonetheless gave us the opportunity to provide patent protection for those sorts of inventions, but without going too far. And as a result, the U.S. biotech industry took off and eclipsed that of Europe. And then I think, David's comments regarding the Chinese approach to IP, I can tell you from my own personal experience many, many years ago, LES was approached by the State Department to give lectures to delegations of Chinese patent office officials. And I was asked to give some lectures and commentary in that regard. And I can remember the first time I did it, it was at a small conference room at Georgetown University, and I started talking about the importance of licensing and IP. And I just got nothing but blank stares. Everybody was looking at me like, you Americans are crazy. And literally within about 5 to 8 years after doing that same lecture, they all went from going to, and the whole room completely understood the importance of intellectual property and what it meant to their economy. And they had completely absorbed that message and adopted that message. And so to your question, Jim, long way around, but clearly the 101 issue is harming predictability, which means it's harming investment, which means it's harming innovation, which means it's harming our economy, but it's also harming the well-being of society as a whole, and not just the U.S., the society globally. The pandemic has, in my mind, shined an enormous bright light on the importance of innovation and how important it is that we have a robust and vibrant pharmaceutical and biotechnology industry. We have shattered records in terms of our ability to produce an effective therapy or an effective prophylactic, if you will, to infection of a global pandemic. And the fact that we now have policymakers and legislators who are still demonizing the biotech industry and the pharmaceutical industry is cognitive dissonance to the extreme. So, in the world of LES, we represent licensors and licensees. We understand the importance of a level playing field, and it doesn't matter which side of the table you're on. At the end of the day, you want to know whether or not you're negotiating over a durable asset that when you buy it and you drive it off the lot, it's still going to work. And if you don't have that confidence, well, you're just not going to buy it and you're not going to invest in it. And so consequently, I think that the 101 issue, I agree with the previous panel, the 101 issue is a gateway issue. It is absolutely essential to get it and to get it right. And throughout most of my career, 101, as the previous panel said, 101 was a non-issue. It was completely ignored for the most part, except for the rare occasion where you had somebody coming in with a perpetual motion machine. And I will say that I did have a meeting in my office one time with a fellow who told me that he had a formula for converting gasoline and cyclohexane into gold. And he wanted to know if I was willing to take his case against the U.S. government on contingency, because he figured 1/3 of all the gold in Fort Knox was a pretty good deal. I told him we weren't really in the speculation business, and contingency fee cases were not in our bailiwick.
I actually just want to add something on that. So it's kind of funny because, Brian did the LES conference in education here in the U.S. Well, I was a CEO of LES. I went to China and spoke at the International Import, I think it was exhibit in Shanghai. First of all, that was a very interesting experience. They shut the entire city down, and it was quite beautiful. But in the room that we spoke about IP, there must have been at least 1,000 people. And everybody in the room, I guarantee you, knew what intellectual property was, they knew what licensing, and they were there to learn how to make their intellectual property better, to make it viable for licensing, and to make it global. In addition to that conference, I also spoke at some smaller ones where you had literally students that were really trying to figure out and understand patentability, how to get their inventions, how to get their company's inventions through their own patent office. And what really struck me the most was their understanding of the law, but also that their culture still was shining through, where one of the biggest questions that they asked was, how do I overcome a rejection on something that I've already patented and that's now put up against my patent? I said, well, you don't. You already have the patent on it. but they kept going back that copying is still kind of one of those things that they could do. But be clear, they're definitely in that space to understand, to license, and know that when we're not willing to protect our intellectual property in the manner that we can under a 101, they're there, and they will. And they're happy to take that business opportunity.
Well, that leads us to the matter of PTO Director Iancu issued guidance on 101, which I think most of us in this room probably were very favorable toward that and thought it was constructive. And it was regarding patent eligible subject matter, and it was considered to have been helpful to patent examiners, patent agents, and others. But the Federal Circuit declined to follow the guidance. So much for deferring to administrative branch bodies. David, what's your view of the guidance? How's it been helpful, and what are its shortcomings?
Pardon. I'm told that I talk too loud, so I'm not sure that this is a necessity, but I think Director Iancu did a creditable job. Certainly our members who have to deal with it in the real world were very pleased that he tried to draw a reasonably straight line through a confused area of the law. He obviously, as an agency head, had to make do with what the courts had left him. He couldn't go outside of that, and he, I think, attempted to do that. Of course, the courts do get the last word. You and I both worked on the Hill. We, as someone said in a bill drafting meeting one day many years ago, don't you guys have some boilerplate language you can put in there, you know, that says, we really mean it this time? But, you know, so yes, he certainly did, but there are limits to what an agency head can do, and plainly the statute and the way the courts have construed it are those out of bounds.
Well, Brian, what are the limitations of 101 guidance, especially in relation to patent licensing and transactions?
Well, first of all, I want to commend Director Iancu for doing a great job and bringing a great deal of predictability, transparency, reliability to that analysis, at least within his ambit. And I think he did a great job of cleaning things up from what had existed before and what had been created by the courts. As you noted, the Fed Circuit has refused to embrace them, certainly refused to be bound by them, and rightly so, says case law is case law, and case law controls. But I think that it highlights the fact that there is a real problem here. And again, getting to the issue of predictability and reliability, when people are negotiating licenses, they want to know that that asset is something that is dependable and is something that they can literally bank on. And you know, oftentimes these agreements, and particularly in the pharma and biotech industries, these development regimes take place, and these strategic alliances take place over the course of a decade or more. And so we're not just talking about the next big thing in the tech industry, we're talking about something that's going to have to go through years and years of clinical trials and a very, very high failure rate. And there's enough risk there already, and unfortunately the courts have greatly compounded that risk by creating the 101 goulash. Apologies, David. And so, you know, I think that the courts have made it abundantly clear that this is a mess. They can't understand it. How do we expect the layperson, the investor, the business person to understand it and to make reliable, dependable business decisions based upon it? So, you know, I think the clearest message that I hope Congress is paying attention to is judges at the Court of Appeals for the Federal Circuit are literally pleading with Congress to fix this mess. But yet we still have obviously people who are opposed to reform and opposed to clarification, who are arguing that everything's just fine the way that it is and we should just leave it alone. And I can't imagine anybody subscribing to that view other than those who have a clear vested interest. And so consequently, the fact that it's proving challenging to get this initiative off the ground is quite perplexing and disappointing. But it is what it is, and the wheels of democracy grind slowly.
Hopefully they still grind. My last question is this, and this is the lightning round question. So we'll start with Kim, we'll go to David, then to Brian. Is how has the uncertainty and unpredictability of patent-eligible subject matter disrupted the rule of law?
Well, it clearly has. There's reliability. You know, it's the rule of law is something that we've been able to settle on, to understand, have predictability in where the courts are going to have. It's stare decisis, going down the understanding of what the next case should be. As I think it was Judge Michel that basically said, in being 22 years on the bench and chief of the Federal Circuit, if he can't understand what the next case is going to come down or the predictability of that, then who else can? So we're stuck in a situation where even the most sophisticated minds in this industry are at a loss to how things are going to be going. And so how are we going to understand what an individual inventor or somebody that's applying for this? There is no rule of law to follow. They're having a very hard time with that.
David?
Thank you. I don't really have that much to add, but the flip side of clarity and predictability is reliance. And if you cannot rely on the law being as you think it is, then really the entire system breaks down. People make decisions based on that, and having a moving target is simply not conducive to the rule of law. And that's a good place, I think, to give Brian the last word.
Well, thank you, David. Well, I guess I would start off by saying that policy by precedent is a really bad idea. For most of my career, if the Supreme Court took a patent case every 5 years, that was a lot. Now they take 5 cases every year, it seems. And no ill intent toward the distinguished members of our Supreme Court, but the interplay of sections 102, 103, and 112 are very subtle, very complicated. I would say most of the precedent in this area has conflated those 4 areas of law, and it has imposed 102, 103, and 112 on 101. And some members of the tech community advocate for that because their view is, well, 102 and 103 aren't doing their job. So their solution apparently is to make 101 a super version of 102 and 103, which defies everything we've all been taught about statutory construction. So I think that we can't leave this to the courts. It's episodic, it's unreliable, and it's not a cohesive policy. And what we really need right now is a cohesive policy to put us in a better competitive position relative to other countries such as China, which are weaponizing their IP system.
Thank you, panel, for this illuminating discussion on the real-world effects. And now, our next panel, please come up, panelists.
Ready to go. Great job.
Well, our final panel has a great thing to do, and they're going to tell us how we might escape dystopia. If not end up in 101 utopia, at least escape dystopia. We have 3 excellent panelists for this, And this panel will be led by David Kappos. David Kappos is a partner at the law firm of Cravath, Swaine, and Moore. And there he counsels clients on a wide range of IP issues. He's globally recognized as an IP expert and has recently received many honors and awards, most recently the IP Watchdog's very first Paul Michel Award. Mr. Kappos served as director of the PTO from 2009 to 2013. He led PTO during the America Invents Act debate and enactment. He re-engineered PTO's management and operational systems and engaged with stakeholders, both domestically and globally. Mr. Kappos brought with him the experience from more than 25 years at IBM, which I always understood it to stand for I'm being moved. That may or may not have been your case. But at IBM, David started as a development engineer. He spent his last 6 years there as the chief IP counsel. Apropos to today's topic, David Kappos plays a leading role in seeking to repair patent eligibility doctrine. He was a witness, too, at the Senate marathon hearings in 2019, thanks to Brad for putting that marathon together. And he and Judge Michel filed an amicus brief supporting American Axle along with Senator Tillis, and they requested that the Supreme Court take its appeal. Mr. Kappos has also teamed with Judge Michel doing yeoman's work together on working to build consensus toward a 101 solution. We thank you for that and welcome you. Brian Pomper is Executive Director of the Innovation Alliance, a coalition of a broad range of R&D companies. He's a partner at Aiken Gump, and there he represents clients on intellectual property, trade, and other matters. He co-leads the firm's public law and policy practice. Mr. Pomper is a registered patent attorney who worked for several years on Capitol Hill. He was the chief international trade counsel on the Senate Finance Committee for Chairman Max Baucus. There, Brian advised the chairman and finance committee members on international trade and economic policy. On policy issues, Brian has advocated before Congress, the White House, federal agencies on IP, international trade, and strong international IP protections. Welcome, Brian.
You can keep mine short. Nothing to say.
Brad Watt serves as chief counsel for ranking member Thom Tillis on the Senate IP subcommittee. As chief counsel, Brad plans and implements the ranking member's legislative and oversight agenda on America's innovation economy. As majority chief counsel in the previous Congress, he oversaw 17 legislative and oversight hearings and multiple staff briefings on IP issues, ranging from patent eligibility to reforming the Digital Millennium Copyright Act. And he was also key in the enactment of several important IP laws last Congress. And Brad served as chief counsel in Senator Tillis's personal office and spent 2 years as chief immigration counsel to then Chairman Chuck Grassley. And he began his career with Senator Jeff Sessions as a legislative counsel. Among his portfolio was IP issues. So welcome, Brad. Also a repeat speaker. I'm going to turn this over to David to manage, and thank you so much.
Okay, well, thanks, Jim. I guess we can go without a mic here and I'll just project. Let me first say thanks to the Eagle Forum and to Jim. All right, switch it around if you want to. All of us Davids have voices that could project very well. So, first of all, to the Eagle Forum and Jim, thank you so much for convening this. For so many of us in this room, including those of us up here now who've worked for years on 101 reform and feel like it is years away from getting done, it's it's really encouraging to have the Eagle Forum, to have an organization continue to focus and not, frankly, give up and say we're going to move on to something else. So thank you. Let me also start by saying thanks to Brad especially, and folks in the room who don't know need to know it is Brad who is carrying the laboring oar in giving us the energy to keep going and keep trying and keep listening and keep talking and sometimes keep banging our heads against the wall on this issue. So Brad, you are a real shining light and a testament to what's really the best about our government and can really work. Thank you. And of course, Brian, great to see you and great to be teaming, and thank you for all you do at IA. So didn't want to leave you out there. But I'm cognizant we've got very little time, get right into it. Let's start with a discussion about getting into what's going on. So Brad, we'll start with you. We don't need to go back to the roundtables of 2019 and the discussion draft and the hearings and all that. I think people know about that. Manus did a nice job earlier of summing it up. But talk about, what from your perspective has been going on in really the last couple of years now since things kind of went, under the surface a bit. And especially the last, say, 6 months, or this term of Congress, to keep discussions going in a constructive way.
Yeah, thanks, Dave, and thanks to you and Jim for the kind introductions. But just want to really emphasize, it's not me that's keeping anything going. I'm just kind of a servant of, Senator Tillis. He's the one that's actually passionately committed to this, and sometimes to my chagrin makes me work on it, depending on the day and the outcome of conversations. But the credit really does go to him as someone who used to work for Wayne Laboratories, who has a background, at IBM. He gets the issue kind of at a level that some members may not. And so, he really is the leader on this, and I'm grateful to get to work with him. Before I answer your question, glad to be here today with all of you as well. Thank you for the invitation. If you'd have told me when I was a law student I would be on a panel one day with a former PTO director, I would have laughed and said, give me some of what you're smoking. But it just goes to show you that knowing how to drink whiskey and tell a joke can get you anywhere. So kind of to your point, recapping where things have been the last few years, as people have surveyed here, we had a lot going on in 2019, and then things I think publicly appeared to taper off, but privately behind the scenes, there's been a lot of work going on since then. As many of you know, Senator Tillis has remained active on this issue. He was able to file an amicus brief with Mr. Kappos and Judge Michel. He and Senators Cotton and Hirono and Coons have a study underway at USPTO on the state of eligibility. And then at the start of this year, he, along with Senator Cotton, really started convening a broader stakeholder process to see, what progress can we make in the long term in terms of finding any level of consensus, no matter how narrow, between kind of vying and competing interest. As Manus noted, that's going to be a very slow and tedious process, and we have to look at this kind of in terms of the long game. As Dave knows very well, as many of the people here know very well, right? Major pieces of legislation that are kind of fundamental to the core of our economy and intellectual property system don't happen overnight. They take years of grueling stakeholder consensus and work, and Senator Tillis very much views this issue in that vein, and he understands this is really a whole of second term project, not something that we should try to rush, because if we do, we risk doing it wrong. It's better to take it slow and do it right and build the necessary consensus to actually get something done. So hopefully that answers the question.
Okay, Brian, would love to get your comments, and then I actually want to come back and go really deeper on a couple of things.
Good. For a second, I thought that was me. Glad it wasn't. Let me just echo the thanks to Jim and others for inviting me here. I want to say Manus earlier complimented Jim, and I just so agree. And one thing, how important Jim is to this whole debate, and something folks may not appreciate about Jim, I always feel like writing is a lost art. And Jim is a beautiful writer, for those who may not know that. I just want to say that. And truly, to Brad and Senator Tillis, for their just continued commitment to this. I mean, this is a pretty dorky, wonky, complicated subject matter. And as Manus noted, it's hard to get members of Congress interested in this, but Brad and Senator Tillis have just remained on it, and I'm just very, very thankful that they continue their interest and work on this. So, look, I agree with everything that has been said. Truly, it is a complicated matter, and it's more complicated because it's some of the folks who are involved in this debate are not coming at it from a strictly patent perspective, right? They have other perspectives, and candidly could really care less about the patent system. I'm thinking from my side of the aisle, the ACLU, very important constituency in the Democratic side, who is dead set against any changes in 101 because they're worried about patenting life forms or the BRCA gene. They worry about kind of the present health of people, and they're not thinking so much about the future and what their positioning could mean for the bell that doesn't ring in terms of cures and treatments that don't happen. That makes it very hard, right? It's one thing to get people who are all talking the same language in a room and try to hammer out an agreement. But when you get people who are really coming at these issues from completely different vantage points with totally different worldviews and areas they care about, that really, I think, makes it even that much more complicated. Manus also mentioned something that I think bears noting here. The Obama years were difficult for the latter Obama years. Let me be clear. Were difficult for folks in the patent community. I think we had a whole White House event on patent trolls, a 2-day event focused just on patent trolls, and there were so many efforts at that time to weaken patent efforts. I feel like we've just made it out with the skin of our teeth, candidly. The Trump administration, and to be clear, I was not a supporter of the Trump administration, but they were great on patent rights and did great things, I thought. I think Director Iancu picked up in the Dave Kappos tradition. I mean, just a very kind of supporter of patents and the rights and spoken about it well. I will say this, when in the election in 2016, when we were speaking with the Clinton campaign at the time about patents, saying like, hey guys, this is an issue that has not been great during the Obama administration. The responses back we were getting from the Clinton campaign was, hey listen, we got it. We understand Obama screwed this up. He thought Google spoke for all innovation in the United States. We get that joke now. That's not the case. We understand that there's a broader community that, it's really important. Of course, the Clinton campaign didn't win. Fast forward to 2020, you now have a lot of those same people who were involved in the Clinton campaign in the Biden administration. So I thought, great, maybe they'll be better, right? They won't be. It won't be like Obama 2.0, like people had been fearing. I will say though, that it kind of seems like that's how it's going. In fact, in some ways, even worse. And I've thought to myself, why is that the case? Why is that the case when you've got an administration that seems to be pretty focused on the domestic economy? My God, why would you undermine patent rights if you're focused on the domestic economy? They're focused on competing with China. Again, why would you undermine these rights?
National security.
National security. I mean, my God, you could just, they should be a natural ally for the pro-patent community. And I think part of the reason why they are not is, frankly, personnel. I mean, they have allowed people into positions of authority who are really antitrust experts. They're folks who are very skeptical of monopoly rights. And I think like Tim Wu is the person I would name kind of most prominently, but there are others throughout the administration. And I think that's one area that I don't know that we've discussed much, is this intersection between antitrust and patents. I think actually that's why Stephen Breyer is the way he is. He's an antitrust guy, and why he sucks so bad on our issues. And I think there are a lot of, I think that can explain a lot. I feel like that's in part why the administration appears to be headed down the path that it is on patents. So unfortunately, I'm a glass half empty person by nature, and I'm a little nervous. Here we have the Leahy-Cornyn bill introduced today. I feel like the enemies of patent rights are on the march. So that's my cheery assessment to start out.
Thanks, Brian. So as a glass half full kind of guy, I still would have to say I agree with you. It is not looking good so far. I think we have to be clear-eyed about it and say it's not. But Brian, you said something that's really, really important. I want to come back to it and go deep for just a minute while we have time. So one of the things that we're learning from the current process that Brad articulated, and I'm cognizant that it's under Chatham House rules, so I'm not going to expose specifically what any particular person said, but there was a sentiment in a recent call that a number of us in this room were on, in which a representative of the skeptics of 101 reform, to call the other group that, said, in effect, there's been an explosion of diagnostics since the Four Horsemen of the Supreme Court. And Brian put his finger a minute ago on what's going on with that statement. It's actually a true statement, and it teaches us something about the different ways the two sides are looking at the debate. And I want to use it, Brett, if I can, to come back to you and get your insight on, how you think about the policy setting then, now knowing that this is what we're coming down to. The reason that the comment is true, I understand, is that there are now more test labs, instances of diagnostics available for existing diagnostic testing. So the BRCA2 test, as an example, there are lots of places you can get that test now, and there weren't when the Myriad Mayo cases were going through the courts, because the patents were in place. But as Brian points out, that's a true statement, and it's important. And let me stop and say it is really important for people to get today's diagnostics at reasonable prices. I don't think anyone in this room would disagree with that. But what that's talking about is optimizing static competition, right? It's optimizing price and choice around the innovation that was made in the past and has already got a sunk cost and is already in the marketplace. What we're talking about on our side of the 101 debate is the therapeutic or the diagnostic that doesn't exist yet. It can't be priced at any price because it doesn't exist, right? And so I totally credit what the other side is saying as being important, but what we're coming down to, I think, Brad, is the nub of a major issue here, which is it's important to control prices on existing diagnostics, but if you don't provide for innovation incentives, don't plan on having any new diagnostics, and therefore don't worry about pricing those at all. So with that, so I think we really are coming down to that point where we're going to recognize that's what the two sides stand for. And both of us, I would say, have very important points to make in that regard. So with that as a long setup, Brett, would very much be interested in your thoughts on that being a point now that's becoming very clear through the discussions that you're brokering. What does the Senate then do with that?
Yeah, I mean, I think the key to any kind of successful legislative conversation, regardless of the issue, but particularly, to an issue like this that is, wonky and dorky and, nerdy to an extent, is realizing, right, that there are legitimate, and I use the term legitimate, equities that people have, and those have to be accounted for, right? No one is ever wholly right. There are always perspectives that are, legitimate and need to be considered. Just from, I think, a standpoint of reality. Independent of that, as many of you know, and for some of you who may not be as engaged on the Hill, right? But Brian can attest to this. Congress is a consensus-oriented institution. Absent a handful of big things like we're seeing in the coming weeks, most legislation passes through a consensus-oriented process. And so, for better or worse, as someone who kind of views myself as a practitioner of realpolitik, you have to take into account those things. That doesn't mean, you roll over and cave on things that may not be legitimate or unsupported by facts or realities. But for things, that are, you have to take into account and try to fix them and forge some type of consensus. Now, I think the example Dave brings up, though, would be an example of, something that's kind of outside the bounds or the four corners of a conversation, right? Because it represents a fundamental philosophical difference. You know, for Senator Tillis, for example, there is a strong just philosophical belief that you have to have the right legal frameworks in place to encourage that new type of innovation for things that we can't even envision. And again, to your point, that doesn't mean that access isn't an issue and price isn't an issue and competition isn't an issue, but at the end of the day, if we don't have the proper legal framework in place, those conversations don't matter because people don't have access to a product. And so trying to conflate things like drug pricing or things like patient access with patent eligibility are not only unhelpful, but they're not a legitimate, at least from Senator Tillis's perspective, point of conversation. Now, having a thoughtful conversation about how patent eligibility reform could impact those things and their interrelationships is fine, but at the end of the day, patent eligibility reform isn't a drug pricing reform debate. It's not a antitrust debate. It's not an access debate at its core, even if on the periphery we may have to touch on those things.
So Brent, further to this panel, get Brian's comments on this too. You know, we're trying to talk about solutions, and I think you just nicely put your finger on where this goes. There is a drug pricing issue. It's not a patent issue. Is there a path where we somehow do something, help the folks who are interested in drug pricing, which is probably everybody, to take their issue to the right place in Congress and decouple it from the patent eligibility issue? Or is that too Pollyanna to think that we would be able to separate these two things and sort of help the other side go in the right direction with the legitimate issue that it has? Right, Brian?
Well, let me say it to you this way. Folks know who Samuel Gompers was. You know who that was? Like the AFL guy back in the day. And I remember reading about him, something that really stuck in my head, that he was interviewed. He said, well, the interviewer asked, well, what do you want for the labor movement? What is your goal? What do you want? And his answer was, more. And that always sticks in my head as one of those truisms in politics, as I think of. And so for me, when you ask me, is there something we could give to the folks on drug pricing who care about access to medicines? And honestly, I think it is a never-ending maw of need. I don't think there is ever anything that you could give them that was enough. Maybe give away medicines for free. Truly, and Brad's absolutely right. Like, I understand you have to, walk in people's shoes to understand their perspectives, and the goals are very different, right? I mean, Dave, as you noted, we think about, I think most of us, think about how are we incentivizing continued research and development into products and things that are going to improve the lives of Americans and everybody around the world. There are groups who have a perfectly legitimate perspective of, no, I need to serve people now. And the best example for me, I really admire this group. On the other hand, I detest them because of their policy positions. Thinking Doctors Without Borders, right? How can you think this is anything but a wonderful group, right? Of volunteers. Oh my God. Oh my God. Exactly. Like motherhood, apple pie, and doctors saving kids who are dying of horrible diseases. Well, it's a wonderful organization, but they are terrible on patent policy. And why are they so terrible on patent policy? Because they are concerned with the here and now, right? They want to save these kids now, and we need to stretch the dollars as far as we go. We need free stuff. So they are always on capital. I remember back in my day on the international side, always against anything that's going to extend monopolies or, frankly, do things that we would think is good policy. Not because we're evil, horrible people, right? We should have a different perspective. So I think from the standpoint, is there anything we can give them? I'm very skeptical we can. And that's what I mean when I say it's, you do have people like the ACLU, you've got people like the drug pricing people, others who all have the legitimate perspective, all have to come to some reasonable consensus. I wouldn't say it's sort of consensus driven, but there has to be a broad kind of based understanding of the direction that we're going in order to get there. And it's hard for me to see how we get from here to there absent more years of discussion.
I'll just add to, it's important when you're having these conversations to try to reduce what may be hyperbole, i.e. we're concerned about drug pricing, which is, again, a legitimate concern, but reduce it to, okay, well, what's the patent aspect that you're concerned about. Your concern is with drug pricing. How does that relate to patents? Well, we're worried people may be securing patents on things that aren't novel or not obvious or aren't scoped properly. Well, okay, how then in the context of an eligibility conversation do we address that concern? Right, at the end of the day, an eligibility conversation can't be about, Medicare negotiation or other issues that have their own policy debates. But if your concern is about drug pricing, let's reduce that concern to how it relates to eligibility reform and patents and address it that way. I think keeping things in bounds is important. Same thing with genetic testing. Is your concern that somebody can't get a confirmatory test, or is it that you want a free test? Because I can't work on a free test because that's outside of my lane. But if your concern is making sure someone can get a confirmatory test, that's a relevant conversation to have. And so I think it's important as advocates, as you're talking about these things, not to just write off those concerns, because if you do, candidly, you're going to lose credibility, including with someone like my boss who's passionate about it. But it's instead, how do you reduce that concern to being relative to the eligibility conversation?
That's a great point, Brad, and that could be fertile ground for future discussions between the two sides, like the access issue that you mentioned, second confirmatory testing, which we've tried to address and haven't really got to the nub on that one yet. I'll do a very quick lightning round because we're just about out of time here. I want to come back to something that we really need to do, I feel like, in this debate, which is to get additional members of Congress on board, interested, and paying attention and part of the team, if you will. We've got, of course, Senator Tillis, been a brilliant leader. We got Senator Hirono, who's great. Of course, Senator Coons, who's great. But the list starts to drop off pretty quickly. So just quickly, each of you, I'd love to have a final comment on, what is it going to take to get the next 5 senators and 5 members on the House side interested?
Yeah, and I just want to add to Senator Cotton has really been a champion for this. He has been Senator Tillis's probably strongest partner on this issue for the last year. It's okay. Senator Cotton is new to this issue, but since he has come onto the issue, he has been a tireless advocate, and he deserves as much credit for this process as Senator Tillis. But Senator Cotton is actually a great example of how to engage members, right? Senator Cotton's staff were new to this issue, and they held a series of meetings with stakeholders and really learned about the national security implications of this, i.e. China, American competitiveness, and it clicked for them. And thank goodness it has, because I don't think I could carry the workload without them. But I think that's key, is if you're going to engage members, number one, as stakeholders, you've got to be willing to spend the money, candidly, to do it. The kind of massive PR campaign that opponents of reform wage. And then number two, you have to make it relatable to them. Just coming in and saying, well, the law is mucked up. Well, lots of laws are mucked up, right? That's not going to engage someone. You have to make it relatable to their particular policy interest and their particular states. A senator who's not from a biopharma state isn't going to care that diagnostics can't get patents. They might be a little concerned, but at the end of the day, it's not their bread and butter, nor should it be. If it's impacting agriculture or plant patents, which I know is a different statute, but if it's impacting manufacturing, like garage door openers, maybe it's a bigger concern for them. So having that tailored message is critical.
Yeah, I'll just take 30 seconds. Agree exactly. Brad said, I agree with him. Manus said earlier, is go to some of the other committees who focus on these issues also from a different perspective, or can focus from a different perspective, like intelligence and some of the others, foreign relations, there's others. I will say too, again, continuing with my glass half empty view of the world, I think this is going to get worse in the sense that I just think, yeah, I know.
It can't get it.
No. What I mean by that, yeah. Let me clarify what I mean by that, is that I think it will become more and more obvious the harm this is doing to us.
Wait, that's good.
And that's my point, is that I think will help energize more and more people as time goes on. But it's a shame that we have to rely on that.
Can I just piggyback off that real quick? I think you're right, Brian. Absent reform, it is going to get worse for all of you. I don't know if that's necessarily going to help you unless, as advocates, you wage that type of PR campaign. Because I can tell you, even me, being steeped in this issue, working on it constantly, 7 out of 10 communications I get about eligibility are about how great the current law is and how it's helping all these startups and small businesses. And I know this issue well, and I work with most of you. So if I'm getting that, imagine your average congressional staffer who may not have dedicated a ton of time to this issue. So, that is part of it. It's not just hoping that eventually it clicks, right? But really educating the staff. And for every one example of, eligibility is great, it's helping this startup, well, there's probably a biotech startup who doesn't think it's as great, and making sure that example is known. But I hope it doesn't get worse, but I think you're probably right.
So I think what that means is that everybody has to hire lots more patent lobbyists.
Manus is smiling
spend
right
a
now.
lot more money on your patent lobbyists. I think that's the conclusion we've all
Manus
reached.
has business
Perfect.
cards for everyone.
All right, I think we finished on a high or low note. Thank you to our great panelists. And I just got a message. Yeah, please. Brian was going to keep the glass half empty by giving us an update on the Delta variant tonight, but instead Dr. Fauci will come and give that to us. So thank you, Brian, for that. Thank you for great panelists, and it's we're just so grateful that you all, such great, every one of these panelists and all three of our panels could be standalone speakers. And so thank you. Let me say thank you to our sponsors again, because all of this is possible because of our great sponsors. The Acacia Research Group, the Biotechnology Innovation Organization, Dinsmore and Shohl, the Innovation Alliance, and InterDigital. Just so generous with us to be able to have this. So thank you. And thank all of you that are here. Please, if you get a chance and meet some of the folks at dinner, thank them. I do want to mention again, it's a little bit of a roast at this point, but Jim Edwards is an extraordinary partner for us, and we can't thank him enough on property rights, on pulling this all together. So I just echo what some of our panelists said and thank Jim and give him a round of applause. Jim, thank you for this. It was very nice of one of our panelists to mention his writing. He's IP watchdog and a lot of different places. His writing, he's very helpful with all of us with the letters that really inform what's going on. So a great ally. You know, the woman who founded Eagle Forum Education and Legal Defense Fund, the late Phyllis Schlafly, you may have heard this, but I hope it will be new to some, and hearing it again will be informative or reminder. Phyllis watched her father spend almost every evening for many years of her life as a young girl, sit at his workbench and invent a patent and get a patented engine. In fact, in the book I have the book here of her patent writings on patents. We include the patent. It was for a rotary engine, and years later it was used. I think John can correct me, by maybe Hyundai or someone. It wasn't as efficient as the engine, but she came as a young woman. That was in the 1930s to watch her father work so hard and have something that was his, the patent, and it informed her commitment to property rights and to the patent system. And even when she was in the great ERA debate, which launched her to sort of national fame, she referred to inventors and the power of how they improved life for all of us, but especially for American women. And in that book that I mentioned in Chapter 3, in 1986, I think it was, she gave a long speech to the Daughters of the American Revolution, one of their big conventions, and cataloged how spectacular the inventions that happened in America were because of our patent system, because of property rights, but also with just a Phyllis twist, talking about how great it was for women because you had all these inventions that made it easier to be a housewife and to be a mother and all. And she was, at those of you that knew her, she was extraordinary. She also was appointed by Ronald Reagan in her office. She has, which we still maintain in St. Louis. If you're ever in St. Louis, we have an extraordinary archive, and her office is spectacular. And on the wall is the commissioning that President Ronald Reagan did for her to serve on the bicentennial of the Constitution. And they went around the country. In fact, the Chief Justice stepped down off the Supreme Court to serve as chair of that Bicentennial Commission, and they went around the country for 2 years talking about the Constitution. And Phyllis used almost every opportunity she could to talk about the Patent Clause in Article 1, Section 8. So we're so proud of her, and we have, as we've gone forward, we have developed these awards. We call them the Phyllis Schlafly Friend of American Invention Award. And if I can ask you now, Dave Kappos to come back up, Matt Dowd and John Schlafly to please come forward. We're going to award 2 of the Phyllis Schlafly Friend of American Invention Award here today, right now, and then later tonight we'll do another 2 awards. So this award we began a few years ago to recognize leadership to strengthen the U.S. patent system and to advance the exclusive rights of inventors to their inventions for limited times. Recipients have shown leadership by advocating and working for reliable, enforceable patents. They stand up for the inventor's freedom and their freedom to exercise patent exclusivity, John. I was under pressure because John got here, and to reap the fruits of their inventive labor. We've already heard in the introduction of Dave Kappos how he has played such a great role in these previous years. His partner in crime, his partner on this mission is our great friend, Judge Paul Michel. Judge Michel, of course, is the former Chief Judge of the Federal Circuit. Judge Michel, who's been a great advisor to everybody in this room, I think. He's just had a huge imprint on IP jurisprudence. He had 22 years on the bench, but he's also been extraordinary in these years since. He judged several thousand appeals, authored more than 800 opinions, 1/3 of those concerning intellectual property law. Judge Michel retired from his lifetime appointment. Always found this most impressive in a way. He left his lifetime appointment to be able to speak more freely on the need for better patent policy and protection of intellectual property. And I see our friend, the previous director, Yanku, stepped in the back, and I remember going to see him a few, maybe months into his tenure, and Judge Michel was down the hall somewhere advising some of his folks, and I think everybody has always been so grateful, Judge Michel, being able to speak so freely and being out in the community. We, the Eagle Forum, and Jim, we especially appreciate his generosity because every time we have a program, he becomes an integral part of it, and we're really grateful for that. So for several years now, Dave Kappos and Judge Michel have highlighted the scope and nature of the problems in patent eligibility jurisprudence. They've dug into all the details of the Supreme Court, the Alice Mayo framework that doesn't work. And let me just quote Judge Michel, his testimony before the Senate. Quote, "I myself cannot reconcile the cases. That applies equally to the Supreme Court and Federal Circuit cases. Nor can I predict outcomes in individual cases with any confidence, since the law keeps changing year after year. If I, as a judge with 22 years of experience deciding patent cases on the Federal Circuit's bench, cannot predict outcomes based on case law, how can we expect patent examiners, trial judges, inventors, and investors to do so?" These two men put the adverse situation into practical terms and made it clear for all those who are both trying to understand the issues and in the legal setting to be arguing them. Mr. Kappos told the Senate, quote, "Our current patent eligibility law truly is a mess. The Supreme Court, Federal Circuit, District Courts, and USPTO are all spinning their wheels on decisions that are irreconcilable, incoherent, and against our national interest," end quote. Then he said, as a final kicker, quote, "It's easier to secure patent protection for critical life sciences and information technology inventions in the People's Republic of China and in Europe than in our United States," end quote. These two gentlemen can cite chapter and verse of diametrically opposed rulings by different courts on the same patent claims based on eligibility. But this they did in their brief, which supported the American Axle's appeal. And vitally, the two of them continue to bring stakeholders together for legislative reform. We're very sorry Judge Michel couldn't be here with us today, but Matthew Dowd is with us. Thank you, Matthew. Matthew Dowd is himself an appellate and intellectual property attorney. He's the founder and partner in the firm Dowd Shohl. He clerked for Chief Judge Paul Michel at the U.S. Court of Appeals for the Federal Circuit, and he is close to him today. So, without further ado, I'll bring John Schlafly. John, why don't you step up here? Do you want to say anything brilliant before we give these awards?
No, you've done
Oh,
it.
you can go ahead, John. You know, nothing. Take off your name tag for photos. All right, well then, it's my pleasure asking Mr. Dowd and Mr. Kappos to come forward so that we can confer the Phyllis Schlafly Friend of American Invention Awards to Mr. Kappos and in absentia Judge Michel. So please step forward. Over here, either way. We want a good photo. John, here, take this. And give that to Mr. Dowd over there.
One at a time? Or?
Sure, well, all at once. We got the camera here. There you go. That's all right. 1, 2, 3. Good.
Well, thank you very much. I'm a poor substitute for Judge Michel. I'll start with that, but I do want to say he expresses his thanks for this, as you all know, as well as I do. He is strongly a believer in improving the patent system. I clerked with Judge Michel around the same time that Andy Baluch did, and he retired in 2010, but he really didn't retire, as you know. He works more these days than he did when he was on the court. So just want to leave it short with that. We will see him back in action when everything opens up. I'm sorry that he couldn't be here, and so thanks very much.
Thank you. Thank you. Thank you. And please give him our best, and we look forward to that. So that concludes this portion of the program. We have a reception. What are you going to? Do you want, Mr. Kappos, would you like to say a word or two? Come on. Why not?
Yeah, very, very briefly. Just to say thanks again to the Eagle Forum for putting this event together, for the wonderful award, and for championing advocacy in our IP system. Great. So thanks.
Thank you. Thank you. So this concludes this portion of our program. We have a reception that begins in just a few minutes. I hope if you can join us. If you happen to have to leave before tonight's program, just make sure that you're in touch with Jim or John or our team as we continue this important work. It's both encouraging, Brian was a little less encouraging, but encouraging to listen to Brad and make you realize that it's a long haul that we have to be in this together to make progress and over time to work together. So thank you again. We'll see you in a few minutes.